Sticky Tooblack. We're in the trafficking business today. Yeah. So, someone's asking about traffic. So I managed to get something that we used to use years ago. And the way we discovered this one was that the local characters, the local police enforcing characters, sent a friend of mine a so-called a speeding ticket, right? And on close examination, they said he was speeding through a traffic light, and on close examination, it showed that the speed recorded was 0 miles an hour. So we wrote to them and asked for clarification about how traveling or being stationary at 0 miles an hour constitutes speeding, whereby they have a cause to institute prosecution. So they give you a notice of an intended prosecution, right? Because you're traveling at 0 miles an hour, and presumably by traveling at 0 miles an hour, you have caused loss, injury, and damage upon another living being and or their property. Right, so this is straightforward. What needs to go? Well, this is specifically for, I wish I had the proposed liability statement, which is the letter of intended prosecution, but it's a standard template that's been in operation for years and years, so it's nothing new. You see, what the changes that you're going to get are changes to do with very minute changes. So for instance, because everything is being AI'd, everything is being made into artificial intelligence so that you can get a computer to issue these tickets and not living people, a computer that has no discretion. So no one is signing these documents anymore. As long as they have no signature, they're invalid. Period. Right, so what you're going to need is, if you have a name of the alleged claimant, I suppose now they won't put any names in it. But let's say 3 years ago or thereabouts, the legal fiction where we are was that one there. So that's the name that they used to create these charges, and it comes from the central processing unit or whatever they want to call it, and it's also always from a PO box. Now, for the people who come to the meets and the people who get the literature, you understand by now that the PO box is a non-contracting venue. So if you wish to contract with the PO box, you can go ahead, but you have a choice not to. Right? So what needs to go in this one is obviously the details of the claimant, a date, a reference. Their liability statement, proposed liability statement, is going to have a number. The number is the account that they've created to charge the corporation that they expect you to stand as surety for, right? So this is a straightforward response. So as soon as you receive that notice of intended prosecution, this is the one. So it regards conditional acceptance. It's always conditional acceptance. Remember, you have the two options. You can either accept it for value, which means you use your exemption, okay? You use exemption, which is for minor things like traffic. Minor things like traffic, you can use that, your national insurance number. If you have big amounts, then you can use other bonds created in a company whose name resembles yours, and which they expect you to stand as surety. Alright, so that's the game that's being played. So if people want you to stand as surety, without your knowledge and or consent. Righty? So for people who have what's called vehicles or automobiles, you know that you're the target. If you have an automobile and you use it for work, or you use it to do whatever, you know you're the target. All right, so you're gonna get a whole bunch of claims being made against you simply because you own one of these vehicles. Right, so how to respond to this stuff? How do you respond to it? Conditional acceptance, as usual. So I hope you can see that. If not, then you're gonna have to get it from me. I'll give it to you. Right. So it's conditional acceptance as usual, or acceptance. If you do accept it, use exemption to discharge the charge. If you find that there's errors in the instrument, then you accept it on condition. So this is one of the conditional acceptances that we used to use 3 years ago. It goes like, in respect of the alleged notice of intended prosecution, and then you make a copy of it and you attach it to them so they know what you're referring to. Keep the original, because you're going to return it if they don't perform. Okay, so please confirm in writing within 14 days that. The 14 days is optional. You can do 3 days because it's contract law, so you can do, please confirm within 72 hours, and that's still valid. Or if it's a long drawn case, let them confirm within 45 days. That's sufficient time for them to go and do their homework and come back to you with some results and some answers. Public servant. Okay. Now, confirmation within so many days. Number one, that you have evidence of a complaining or injured party. You see, there's somebody who's incurred loss, injury, or damage, and this someone will be able to demonstrate the nature of their injury in court. And you're talking about a court of competent jurisdiction. We're not talking about a magician's court or a county court. We're talking about a court of competent jurisdiction, a lawful court, judicial. So we want to see the criminal complaint. Let's see it. Let's see who lodged the complaint. If it's to traffic, for instance, did the traffic light lodge the complaint saying you were traveling at 0 miles an hour next to me, so I need you to pay me some money for that because I suffered so much since you're traveling at 0 miles an hour next to me? Or maybe the tarmac, you see, because you're traveling at 0 miles an hour. Maybe the tarmac incurred some injury and the tarmac requires compensation. A whole bunch of bullshit. Right, number two, evidence that you have standing to bring this claim and you can demonstrate valid cause. Standing is for living man. Because presumably they're moving against you being the living man. So we're presuming that on the other side there's another living man who has standing to bring this claim. And they have first-hand knowledge that you caused injury, loss, or damage. And on top of that, that you went to court and filed valid cause, which is, it has 3 requirements. 1, violation of a legal obligation. 2, injured party. 3, redress ability by the court. If you want to take it further, you could even ask them this: in what jurisdiction, in what court do you intend to pursue this prosecution? Ask them that, if they know, or if they're willing to tell you. So standing is for man. If you're representing your legal fiction, then status is is the term. Number 3, you can and will clearly identify whether your complaint is criminal or civil. Right? When it comes to traffic, is it civil claim or is it criminal? Because what's happening here is that criminal statutes are being used in civil matters. and public law is being used for private gain. What do I mean by that? Public law is public law. However, when a private for-profit corporation, which is not public, is private, uses public law for its own financial gain, that's both illegal and unlawful. So that's where it's going to stop. Right? Now, disclosure of this information is required in accord with Article 1. Blah, 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 blah. The rest of it is there. Article 1 is still valid. European Human Rights Act, the universal one, the international one as well, human rights, International Convention on Human Rights, requires that every living man or woman be given a fair hearing. A fair hearing means a public servant shuts their stupid mouth and they listen to you speaking. It's called a hearing. You hear me, I don't hear you, you public servant. Right? A hearing, which means you listen to me, what I have to say. It's called a hearing. These public servants don't seem to know that, or people pretend to be public servants. When I come to your venue, you're going to listen, you're going to hear me. You're going to hear me. So that's the Article 6 you can use for that. And the CPR rule is 1.1. I haven't looked at these rules for a while. Should still be the same unless they've changed it, but please confirm by going to CPR and look at it. If the rule is to do with overriding objective, in that the overriding objectives is to make sure that all cases are dealt with justly and that all participants in any case have effective participation in the case. The only way that you can participate effectively in a case is if you're given evidence of the complaining party, you're given evidence of who's bringing the claim and that they did file valid cause in the court, they did sign an affidavit, a statement of truth, and they filed it in court, and it was witnessed by an official of the court. And number 3, they can identify whether they're civil or criminal. Now, if they don't know what these things are, okay, then the claim is not going to stand. Now, we offer expeditious remedy, expedient remedy, prompt remedy, quick, fast remedy for all verified and legitimate claims. Right? So you only give remedy to verified and legitimate claims only. How do you verify? By producing the injured party, producing a copy of the paperwork which is signed that you filed in court as valid cause, and identifying in writing whether your claim is civil or criminal. If you cannot do that, you don't know what you're doing. Now, we cannot give you remedy. Right now, take note that the burden of proof in a criminal matter is on the complaining party, which is them to prove beyond a reasonable doubt that you did commit a crime. That's the only time they can use criminal statutes. And a crime is what? 3 elements. Actus reus, mens rea, you have to think it. Actus reus, you have to act it out, and you have to injure someone. Corpus delicti, injured party. Without those 3 elements, there is no crime. So who did you injure for them to use criminal statutes against you? Maybe it's the traffic light. Maybe you injured the tarmac. Maybe you injured some cement. I don't know. But in any case, before you can participate in any proceedings, you need to identify whether it's criminal or civil, because it's different defenses, if you will, if you want to call it that. It's a different approach. All right? So the second one is beyond reasonable doubt, and they have to produce a preponderance of evidence if their claim is civil. Right? Now, this is critical. Take kind advice that no further correspondence from you regarding this matter will be acknowledged or recognized should you fail willingly and or refuse, fail and or refuse to provide the aforementioned within the requisite time, as this matter will then be considered final, closed, finished, discharged, and extinguished, and your proposed proceedings null and void from the beginning. Okay, and then on top of it you put this document and all others pertaining to this matter may and will be produced in court as evidence, and make sure you do produce this paperwork in court as evidence to say that you do not have sufficient information to take party in these proceedings because you don't have information from the claimant. All right, so that's straightforward. That's a one-pager. Normally this is the conditional acceptance that starts off the a proper response. They're not going to respond to it because because no one's reading. The computer is not programmed to answer these responses. It requires a living man or woman to read the paper and respond to it. But because there's no living man and woman there, you're not going to receive a response. So after 3 days, you send back the original with a refused for cause, right? Refusal for cause is a document saying I'm refusing this for cause because you have not responded to the conditional acceptance that I served to you on this date. All right, so you can take the original back. I'm not going to honor it. I'm not going to act at this direction, and I'm not going to be party to your proceedings. So thank you very much. Okay? Condition is this. Since you are found at fault, if you do write to me again, I may charge you an administrative fee of £250 each time you send me one of your silly, unauthenticated, computer-generated, rubbish, unlawful, racketeering, BS paperwork, right? Talking about notice of intended prosecution. Yeah. So yeah, stick it Tooblack. Stick Tooblack in it. Yeah, so we're gonna give you more. That's just the traffic. We're gonna give you I'll give you everything. I'll give you the council, I'll give you the taxes and all that. The reason for that is because this is legalese language. It's not English. Right now we're dealing with English. However, because these people deal in legalese and fake language, you can still kick their ass with their own language. It's a bullshit language. Doesn't mean anything. What? Okay. Yeah.